What are 10-year periodic charges on a trust? Most people worry that there's some kind of ongoing charge on a trust. I often get the question, what is a 10-year charge? What is the periodic charge? If that includes you, no worries, this video's got you covered. There's a lot of noise and confusion on the internet which gives people the wrong idea. So let's quickly recap what is a trust. A trust is a legal arrangement where the trustees become the legal owners of an item on benefit of someone else, the beneficiary. A beneficiary can also be a trustee. What charges do I need to pay to set up a trust? The biggest headwind with trust is the initial cost. Once a trust is set up professionally and the house is inside of the trust, there should be zero annual cost or zero run rate or annual fees. So what are the 10-year charges of a trust? The 10-year charge is a calculation based on the value of assets inside of a trust on the day before the 10th anniversary of the settlement of the trust. The maximum charge would be 6% over thresholds. What are the entry charges? Entry charges are fees payable if you put more than the chargeable lifetime transfer limit into a trust. Currently, the CLT, or the chargeable lifetime transfer, is £325,000. This means you will pay 20% on the values in excess of £325,000 if you try to put more than £325,000 into any one trust. And for couples, this could be £650,000. What are the exit charges? Exit charges are based on a sophisticated calculation of your entry charges and your periodic charges. If either of those two charges is nil, your exit charge will be nil. Exit charges can be as high as 10% of the periodic charge. Now remember, the periodic charge is only 6%, so 10% of 6% is 0.6%, or less than 1%, generally small potatoes. So why should you not be paying entry, exit, or periodic charges? Paying taxes on assets that are in trust is the complete opposite of successful estate planning. It's literally the opposite of what the intended purpose was. And it means either you are in the 1% of the great and the good, or you've been dealing with somebody who doesn't understand trusts and taxes. For most people, there are no entry, exit, and periodic charges as the values are below the thresholds. And if your values are above the thresholds, your trustees can move assets from your trust into another trust and decrease the overall value within any one trust if they do this before the 10-year period. And presto magic, there's no taxes to pay. So here's what you need to do to not pay the 10-year charge. Legal tax avoidance is possible. You need to speak with a specialist estate planner. A professional estate planner needs to and wants to understand your family situation, your objectives, and the overall size and disposition of your estate. They're going to bring tax knowledge and legal solutions to your situation so that you can protect your assets without paying taxes. And the UK has the dubious honor of having the world's largest tax code. At MP Estate Planning UK, our head of legal is a doctor of law specializing in taxes and trusts. When we set up a trust for a family, there are no entry, exit, or 10-year charges. We've saved thousands of people and hundreds of families from losing their homes to care fees and inheritance taxes through successful legal, tax, and estate planning. The truth is, most solicitors only get a couple of hours of estate law as they go through process of becoming a solicitor, and so you may very well wish to deal with a specialist. Medicine and law, for example, are very broad, and you wouldn't want your GP performing surgery, so you probably don't want a divorce lawyer trying to advise you on a trust. And therefore, when dealing with the sum total of your life's efforts, would it be a bad idea to hire the smartest people you can find? Here's how you can get started with a trust. First, decide who the trustees are going to be. Do you, quote unquote, trust them? Second, decide who are the beneficiaries of this trust going to be. If you're going to continue to live in the house, you are a beneficiary, so make sure that you include yourself on that list. You're probably also going to include your partner and your children as beneficiaries and possibly trustees. Third, contact a professional estate planner. Deal with someone that you can trust, someone who is up to date on their knowledge. Your estate planner should be able to explain both protection and tax solutions on how to protect your estate. Your estate planner should be able to provide you with written copies for draft approval within 48 to 72 hours. And then once you've approved the drafts and checked all the names and spellings, you should receive a courier with all the official documents within 24 hours. Your estate planner will handle all the filings and deal with land registry on your behalf. This can take some time, but don't worry. From the moment you've signed your trust, you're legally bulletproof. If you want more information on how to protect your assets in the UK, click on the link in the description to watch our free virtual training on how to protect your estate in the UK. And if you're interested in our services, you can click the link in the description to book a free 20-minute call with an estate planning professional, and we can help you get started.